Whether you are a non-resident Indian, NRI, an overseas citizen of India, OCI, or a person of Indian origin, PIO, without proper guidance, transferring Indian property may prove to be a confusing and time-consuming process. In this post, we will discuss the top frequently asked questions on Indian property inheritance. Number 1. Can a non-resident Indian inherit property in India? Yes, a non-resident Indian can inherit the property from anyone, including his relatives. The NRI can inherit property in India even from another NRI, subject to certain conditions. An NRI, or any person of Indian origin, can inherit property in India, whether it is residential, commercial, or agricultural land. Number 2. What is the Indian Succession Act 1925? The Indian Succession Act came into operation on 30th September 1925 and seeks to consolidate all Indian laws relating to succession. It applies to succession of property whether there is a will or not. Number 3. What is intestate succession under Indian law? In a case of a person who dies without making a will, the property passes by inheritance as per the personal law of the deceased. This process is known as intestate succession. Number 4. Who can make a will? Section 59 of the Indian Succession Act provides that every person of sound mind, not being a minor, may dispose of his property by a will. Number 5. What can be willed? Properties which are self-acquired can be disposed of under a will. Properties acquired by inheritance or gift, etc., and held exclusively can also be subject matter of a will. Number 6. What is a codicil? A will can be changed by the testator during his lifetime, either by making a new will after revoking an old will, or by amending the old will by a separate instrument made with the intention to make such an instrument a part of it. Number 7. What is a probate? A probate is the grant of administration of a deceased person's estate by the court of competent jurisdiction on the basis of a will. Number 8. What is a succession certificate under Indian law? In the absence of a will, a succession certificate is a document which is issued by the court for claiming movable properties by the successors of the deceased, such as bank or savings accounts. Number 9. What is the difference between a succession certificate and a legal heir certificate? A succession certificate is required in instances where a family member passes away and the next direct legal heir of the deceased is his wife, husband, son, daughter, or mother. This certificate can be used for the purpose of paying certain taxes and accounts. In contrast to a succession certificate, a legal heir certificate is required if a government official has passed away in order to claim a family pension, insurance, retirement claims, etc. Number 10. What are the other methods of transferring property when the person is alive? A transfer can take place when the person is alive through a gift deed. In other cases, a person can claim his right through a partition. If you are looking to transfer property in India, we recommend that you seek professional legal advice. For professional help, please contact our team or use the free assessment form linked below in the description box.